Mentioned before, on these proposals with respect to partnerships, most of the focus is anti-abuse areas in which they feel that partnership laws are being abused for unintended advantage. The debt allocation issues has been a long simmering one that the IRS is working on addressing. On the historic boardwalk case, that the use of they basically used a tax exempt entity, a government entity in New Jersey, to assist in these giving these rehabilitation credits, and the court basically said that was basically selling the credit and disallowed it. But the taxpayer community, the tax preparation community, tax practitioners think that this is a pretty common structure in Code Section 47 won't work without that sort of structure. So there's been a lot of debate about the impact of historic boardwalk. Sun Capital was also a recent decision in which this was really an ERISA decision in which a hedge fund was operating the business as hedge funds usually do, getting it ready for resale and reaping the benefits. And they took the position that they were a hedge fund, they were just an investor. They weren't actively engaged in the trader business of the business that they acquired. But the Sun Capital Court said you are engaged in the trader business, and therefore you're subject to the pension termination liabilities of this business. And of course the hedge fund industry is very upset about this, and it gets into the issue of what is a trader business. This is an ERISA case, but a lot of people are concerned that this could affect what is the trader business for other tax purposes. In general, the definition of trader business has been treated differently for different purposes because, in a tax context, frequently people want trader business treatment so that they can deduct the losses of the IRS instead of fighting trader business treatment in that context. And in the ERISA context, people want to avoid trader business to avoid a pension liability. So you have different positions being taken for different purposes. So I would say that the Sun Capital is probably not likely to have a great impact in the tax area, but a lot of people have been concerned about that. The carried interest area has been also one discussion on this. This is basically the fact that hedge funds and private equity funds, the owners and operators of that, basically get all their money out in capital gains format. Of course, a lot of that could be short-term capital gains, so maybe it doesn't matter too much in terms of rates. And if we got tax reform with a consolidation of rates, maybe this issue would go away too. But basically, the thrust here has been legislative proposals to force hedge funds and private equity fund managers to get at least what looks like compensation for services tax and ordinary income rates versus capital gain rates. But we've had a series of proposals over the years and nothing has been enacted to date. But it's still it's a revenue raiser, which, as I said, there's a shortage of revenue raisers, so this will keep coming up because it's a source of revenue if they can ever find something they can pass. Sort of upsetting of the apple cart in terms of same-sex marriages. For a number of years, we've been having a situation where legally married same-sex couples might, in a state that recognizes same-sex marriage, and there's an ever-growing number of those, they had to file a direct return for state tax purposes and a single return for federal tax purposes, and then sort of do a pro forma federal direct return to get the numbers for their state return. So now we have sort of the opposite situation since the Supreme Court decided in the Windsor case. We've got the same problem only in reverse. In states now that do not recognize same-sex marriage, you're going to have to do in general, the single return for state tax purposes, and the joint return for federal tax purposes, and then do the pro forma federal single return to get the information for the state tax purposes. So the complications haven't gone down. It's just different people will be subject to the complications. And the IRS, when they came out with their guidance in response to Windsor, said that they were going to recognize same-sex marriages based on the state of celebration, not whether that particular state recognizes same-sex marriages. So regardless of the state they're living in, whether that state recognizes same-sex marriages or not, you have to, legally married same-sex couples will now be required to file a federal joint or married filing separately return. The single option will no longer be available. And of course, you all know with all the marriage penalty provisions, if the same-sex couple is dual income, they may actually face a marriage penalty by filing jointly. Well, but for a lot of other purposes, estate planning, health care rights, and hospital access rights, and all that sort of stuff, there's tremendous advantages to having a legally recognized marriage, but it might not be an advantage for income tax filing purposes. So today we have 17 states that recognize same-sex marriage. Utah is not included in here. The most recent activity was with Utah, where a court required them to recognize same-sex marriage, but then within the last week, the Supreme Court put a stay on that. So now, at least for the time being, same-sex marriages are not being performed in Utah. Now, Missouri is an interesting situation there. They have a Democratic governor, and the Constitution does not recognize same-sex marriage, but the governor, by administrative announcement, said under Missouri tax law, we follow the federal filing procedure. So even though we do not recognize same-sex marriages, same-sex couples that file a joint federal return can file a joint Missouri return. I don't expect that to be a policy adopted by a lot of the other states that don't recognize same-sex marriage. But you're getting all these grants there, so you really have to look at each state now on a state-by-state basis to see how they're handling same-sex marriage. But it's really the change in Windsor didn't simplify the issue; it just sort of changed the parameters of the discussion. Also, the IRS guidance said that for legally married same-sex couples, there's an option to go back to open years and file amended returns. And again, if you've got marriage penalty issues, that might not be something you want to do, but it's at least something worth looking at in terms of going back and amending returns for open years. And it is limited to same-sex marriage. The IRS did not extend that change to the civil unions and domestic partnerships. But Illinois just adopted same-sex marriage, but for a number of years we had civil unions before that. But that's not good enough to get you into joint status for IRS positions. There have been on other areas like Social Security and the veterans benefits, there are some statutory issues with respect to the following the IRS policy, which is to recognize same-sex marriages regardless of the state you currently reside in. Under some other federal statutes, there's language that makes that a bit more difficult. So for things like Social Security benefits and veterans benefits, you may still find the state of residence being very important in terms of whether the same-sex marriage will be recognized for those benefits. So just because the IRS has taken this view, it doesn't mean that all federal law. This is another one of these long percolating issues that we were all going to be, GAC is going to be unified under IFRS as part of the push toward a global economy, and everyone is going to live happily ever after. And it hasn't quite turned out that way. The SEC seems to have, I guess, because of the recession and focusing on all these banking issues and stuff like that, IFRS seems to have gotten backburnered by the SEC. they've deferred implementation at least until 2015, and the sense from the SEC at this point is that there's not going to be a complete adoption of IFRS. It will be at most a sort of a modification to GAAP to better comply with IFRS, but it won't be a seamless system. They've a lot of companies already are using IFRS for international reporting, but the IRS or the SEC has been not really coming forward with procedures to help these companies understand how they can use IFRS and GAAP. So people are still sort of left in a quandary and still sort of subject to GAAP for SEC purposes for the present. Supposedly the SEC is still processing information and collecting information about how to implement IFRS, but this has been going on for a lot of years now, and we don't seem to be moving too much closer to the goal. And even the 2015 date could be looking problematic at this